Harrington here, folks. Hope you enjoyed the holidays. I certainly did. One of my New Year's resolutions is to make these videos around 10 minutes and not too much more. So let's dive right into it. All right, so we are talking about international asset protection, sometimes called offshore asset protection. And I know what you're thinking, Jeff, wasn't that episode 8? What are we, recycling material already? All right, hear me out. Here's the thing. Whenever the White House changes hands from Democrat to Republican or vice versa, as it is, in a few days, I always get a series of phone calls of people wanting to know about offshore banking and offshore asset protection. So in anticipation of that wave of calls, which might be a bigger wave than normal this time around, let me see if I can just kind of head some of that off. Part 1, offshore banking. In my mind, you can break down offshore asset protection into two different categories. One is banking and the other is creditor protection. They're related, but each has its own characteristics. So let's start with banking. And you're quite right. I did handle this more in depth in episode 8. So here's what I'll do. I'll put a link below and also links to my online articles in case you want to get a little more detail, because we're going quickly. It's going to be fast and dirty here. Now, when we're talking about parking your hard-earned money in some other country, we're concerned about things like, one, how robust is the banking system? Right? I mean, you don't want to have issues when it comes to being able to reach your money when you need it. You don't need to hear about 3 correspondent banks or, power outages or whatever. You don't want to hear any stories. You want to know that you can move your money when you need to. You can get to your money when you need to. You can see that it's safe. So, yeah, the banking system of that country is important if we're talking about offshore banking. By the same token, you want to know that the government is stable and there's not going to be riots and weirdness happening to your bank. Okay, well, obviously, if we're talking about stability and efficiency and super robust, infrastructure and all that, then, we're talking about Switzerland, obviously. It has all of that and it's very safe. Now, there's much more disclosure from Switzerland than there used to be in recent years. That's become a thing. But it's still considered the gold standard. Okay, now Switzerland's all the way over there. What if you're here in Florida? What might be a backup option? Well, Cayman Islands is well known for its banking system. That might be more close to home and have some other advantages as well. How about this? If you're a Spanish speaker, Panama, very good option. They also have a robust banking system, stable government, everything's in Spanish. But other than that, would certainly be a good option for you. And finally, last but not least, Nevis as part of St. Kitts and Nevis. For some reason, we just focus on that one island, though. So Nevis, English speaking, and they do a great job. That's actually the go-to for my firm. Now, just to wrap up this section, what are some of the pros and cons? Well, the costs, the transactional cost. Switzerland, as we said, is the gold standard, and they charge like it. So be aware of that. I think you'll be happier with the prices in either Panama or Nevis. In terms of the cost of doing business. And then without getting too much into depth on this, you be aware that the laws have changed within the last 10 years. I mean, it wasn't that recently now, it just seems like it. So there's a lot less offshore banking for Americans, generally speaking, because there's much more disclosure to the IRS. We won't get into the laws involved, but be aware of that. I mean, you're not really hiding money if you go offshore. That's kind of a thing of the past. If you think you're going to save money on taxes or whatever, don't hold your breath on that. But, if you like the idea of being diversified, if you think maybe the country is going to go to hell in a handbasket, and you like the idea of just having your money in a safe place that's outside of the United States, the options I've given you are good ones. Okay, that brings us to part 2. Let's talk about what I would consider the asset protection part of it. And there we're discussing creditors and, the protections you can get from potential creditors or existing creditors. Now, the good news here is that the international treaties that have come into place and have very much affected international banking have not really affected the creditor protections that we see in some of the common jurisdictions. And let me tell you, these countries, they make it really tough. Some of these countries make it very tough on creditors who want to pursue you and get to your assets that are inside these jurisdictions. I'm going to give you some names, but let me give you some examples of what I'm talking about. First thing is this: non-recognition of foreign judgment. So, in many cases, if you have creditors, they're going to get a judgment against you. Maybe they already have it. And then what they're going to want to do is, if you have assets in a foreign jurisdiction, they're going to want to just take that judgment to the other country and present it to the courts and expect full faith and credit. And they will get that in most places in the world. The courts will just sort of stamp it, domesticate it, and that makes that American judgment now enforceable in the foreign country. Not so with some of these jurisdictions I'm going to tell you about. They do not recognize the American judgment. So imagine your creditor has gone through all the trouble and expense of getting a judgment against you in the United States, which is not now going to be recognized in the foreign country, so they're going to have to start all over again. And there are good reasons why they're not going to want to do that. For example, some of these jurisdictions require that a creditor, before they can even initiate a lawsuit in that jurisdiction, put up a bond. And I'm not talking about a small bond. I'm talking about in a range from $25,000 to $100,000 bond. So as you can imagine, in most cases, that's kind of the end of the thing. And one other thing I want to mention, just because it's kind of fun. Some of these jurisdictions don't allow lawyers to work on contingency. All right, let me explain what that means. So you know how most lawyers will charge for their fees up front, and you gotta fund the litigation and then hopefully recover at the end of it all. Well, there are some attorneys who will do this work on contingency and say, I'm not going to charge you anything, and then whatever I recover, I'll get a percentage of it, right? Okay, so you would take that deal. But there are some jurisdictions that don't allow that kind of arrangement for lawyers who are litigating in that country. That might seem like kind of a funky thing to focus on, but if you think about it, it's actually a killer. Because if the creditor has to now fund out of pocket a lawyer to litigate in this foreign jurisdiction that they know is creditor unfriendly, that's discouraging. All right, so what jurisdictions would I recommend? Okay, well, the gold standard, just like Switzerland's the gold standard in banking, when it comes to asset protection, the laws and the courts, Cook Islands. Now, they do charge like they're the gold standard. They know that they are. But great, very debtor-friendly laws and policies in place in that country. The other one that I want to mention is Nevis, the small island of Nevis, again, because they have actually the same laws that the Cook Islands have. I think they pretty much model their legal system on the Cook Islands legal system, but they're much more affordable. Part 3, honorable mentions. Okay, Ireland and New Zealand. You did not see that coming, did you? And there's no reason you would. Ireland is part of the EU, so they're stuck with the European Union directives. They don't have any crazy anti-creditor laws that are gonna protect you. And the same is true for New Zealand. They are based on English law, so nothing crazy. I guess we could call this asset protection light. Well, why would I even bring it up then? I bring up Ireland and New Zealand because they are non-red flag jurisdictions. Okay, you can lose business. If you're a business person, and as you are, because those are the people that watch this podcast, you're going to be doing deals. And when the person on the other side of the deal sees that you have a company set up in Panama or the Cook Islands or one of these well-known asset protection jurisdictions, that can certainly be a red flag. I mean, they're going to be thinking to themselves, this guy or gal intends to screw me over, and there's not going to be anything I can do about it. And they would be right about that. So these other jurisdictions, as wonderful as they are, can be a turnoff, and you can ruin deals over that. So if you want some asset protection without the red flag, Ireland and New Zealand. Final thought, is there a winner? Well, in my mind, there is. For our firm, the go-to jurisdiction is Nevis. You'll notice that Nevis appeared on my list for both banking and for asset protection. And I don't think it's really a red flag jurisdiction, maybe just because a lot of people don't know what Nevis is. So for us, that's the go-to. That's where we have our contacts, both in banking and in trusts and in establishing LLCs. I would say look hard at that if you're interested in this topic. So that's what I have to say in this quick refresher course on offshore asset protection. Recuerda que hablamos español. As I said, I will drop some links below so you can get some more information on this topic. And as far as the likes and the comments and all that kind of stuff, I know you'll do the honorable thing. Happy New Year, everybody.